Good afternoon, everyone. I, Dr. Nidhi Singh Arora, Assistant Professor, Faculty of Law, Integral University, welcome you all to the seventh technical session of Module 2 of our Faculty Development Program. The role of correctional institution becomes important to shift the emphasis from the confinement to training, restriction to re-education, and punishment to reform and rehabilitation. The reformative theory of justice postulates removing the dangerous degeneracy in a criminal and affording them a chance to make a fresh start and lead an honest life. This ensures fundamental human dignity, a most essential constitutional and human right. The need and justification of correctional reforms in the form of non custodial sanctions on therapeutic jurisprudence and restorative justice. So, to throw more light on this thought, we have our guest today, Dr. Dalyandeep Kaur Tiwana, as a resource person for this session. Dr. Dalyandeep Kaur Tiwana is an accomplished legal scholar and educator who currently serves as an associate professor at Lovely Professional University, Punjab. Her expertise covers criminal law, family law, and property law. Ma'am holds a BA LLB 5 years honors course, LLM, and PhD from Punjabi University, Patiala, showcasing her strong foundations in legal studies. She has successfully cleared the UGC NET examination, demonstrating her dedication to advancing the field. With 9 years of experience in legal education, she has guided 6 dissertations, supervised 5 PhD candidates, and boasted 20 research publications, including Scopus Index journals. Ma'am is also a prolific presenter, sharing her insights through over 30 papers at a national and international conferences. Ma'am's impressive academic achievements and dedication to legal education make her a valuable resource person for the faculty development program at Integral University, Lucknow. Ma'am, I welcome you with all my heart and on behalf of our team. Now, over to you, and please, ma'am, the stage is yours.
Thank you so much for the brief introduction, for a beautiful introduction, Dr. Nidhi. And a very good afternoon to all of you present here. So I can't see any of the, you can say, participants. So I hope that we are having a number of people associated with us right now. Before you can say venturing into the topic given to me for this very particular program, I would like to extend my, you can say, warm gratitude to Dr. Naseem Ahmed, Dean, Head Faculty of Law, Integral University, and all the staff here, those who have, you can say, made this beautiful program to happen by their hard work. Not taking much time, just coming on the, you can say, topic for today, that is the correctional institutions and the alternative methods. Although you can say when we study our criminology and penology, so this is one of the most, you can say, theoretical topic which as a students we study. But if we look at it from its practical angles, it is one of the most important topic on which we need to deliberate today. It is not only the, you can say, the information exchange has to be there, right? So it is the debate on how, you can say, our prison system is working today. As of you can say, as a law student, and generally when we study the punishment, the theories of the punishment, right, under our criminal laws, so we came to know that what is the objective of the punishment, starting from the deterrent towards the, you can say, rehabilitation and the resettlement of the offenders. So talking about the modern, you can say, era, talking about this era in which we are living, so we find that what is the purpose of the punishment? Purpose of the punishment is not just simply the imprisonment, right? Not just simply sending the offender to the jails. This is not a purpose of the punishment. Purpose of the punishment is to reform them so that they can come up whatever they have done, right? So once they are into the prisons, so the prisons should work as the correctional institutions, right? They should, right, in that very particular prison system, they should come to know about that what wrong they have done, and what are the ways with which these wrongs could be undone, and for that what are the required amount of the training which is required, our administration is providing them, be it the educational, be it the vocational, be it the, you can say, the social lectures, be it the religious, whatever the ways with which we can, you can say, rehabilitate or we can refine the criminal, that is the object of the today's penology or the criminology system. Now when this very generally, whenever we talk about this very particular topic, role of the correctional institutions, so what the so these very general idea is the rehabilitation in today's world. But when we talk of the correctional institution of any nation, it is deeply rooted in the history and the tradition of that very particular society. So the inception of the prison system or the inception of the prison reforms can be attributed to the fact of the recidivism in our society. So the reform as such, the word has been taken from the Latin word that is a reformum, which means to change, to amend, and what is wrong and what is unacceptable, to change that very particular thing. If I talk of the correctional institutions as such in an academic categorization, if we'll do it, so we talk about the institutional treatments, we talk about the non-institutional treatments, and we talk about the hybrid treatments. When we talk of the institutional treatments, first and the foremost, we have the prison systems, of which we all know, right? The most famous one, prison systems. Then we have the observation homes. Once the Children Act, the juvenile laws came into the force, we came to know about the observation homes, the special homes, the children homes, then aftercare organizations, right? In which our NGOs are playing a very, very vital role. Then the protective homes for the women and the beggars home. So that means institutional treatment means it could be, you can say, in majority of the cases it is sponsored by the state, it is a responsibility of the state, but sometimes it is the NGOs or any other organization which is working in the close aid with the, you can say, state machinery, they are taking the responsibility for the institutional treatments. So in the case of the institutional treatment, the, you can say, the prisoner, the person who is in conflict with law, right, or the accused person, that person remains in the continuous supervision. Right, so wherever, you can say, he is lodged, whether it in a prison or in the observation home, he is continuously in the state of the supervision. So in that very particular supervision, the efforts should be made that the person has done something wrong, we have put it in the prison, that is the end of the story. It should not be there. So the purpose of the punishment, the problem of the prison system is that offenders is sent to the prison for the purpose of the punishment. So the purpose is not only sending them to the prison because they have done something wrong, right? So you're lodging them into the prison, you're curtailing the liberty of someone due to the factor that they have done something wrong. How the state is contributing towards their betterment so that they can become the, you can say, a citizen, a good citizen in the society, and they can integrate with the mainstream society. That is the most important purpose of the institutional treatment these days. Coming over to the non-institutional treatments, our programs like the parole and the probation, furlough, right? So these very particular things, they play an important role for the rehabilitation of the offenders, right, in a non-institutional setup. In this non-institutional setup, it is not always that it is without supervision. Sometimes it could be with the supervisions, depending upon the gravity of the offense, depending upon the other, you can say, prison manuals of the state and administrative restraints, right? Then coming over to the hybrid treatment, which is quite new in our country, that when we talk about the community services and the work release, right? So these are some of the, you can say, correctional institutions which are operating within the system. When I talk of the prisonization, what do you mean by the prison, right? So it is a kind of a punishment and a sort of institutional place where the under trials or even the convicts are placed. So where there is a society, there is a crime, and where there is a crime, there is a prison, right? Any society which is without the crime, we can't imagine it, right? So it would be a perfect state of affairs. Unfortunately, that is not there. So whenever there is a crime, in order to give the, you can say, a punishment, or in order to reform the criminal, we have the correctional institutions. Uh, but from the times immemorial, what we talk of the prison. Prison means any jail or the place which is used permanently or temporary under the journal or the special orders of the state government for the detention of the prisoners, and it include all lands and buildings but does not include any place for the confinement of prisoners who are exclusively in the custody of a police. So this is the definition as per your Prison Act 1894. So this very particular act is around 130 years old law on a place, right, which has been recently replaced by the Act of 2023. So according to this very particular act, that any building which is being, you can say, used for the purpose of the detention of the under trials or the convict, that would be designated as a prison. But yes, the thing is not coming under the police custody. So this definition is making, you can say, a difference between your judicial custody and the police custody. So when we talk about the prison system, generally we talk about the judicial custody, not the police custody. So organization of the prisons, right? So how the organization and the structure of the prisons do work. The origin of the prisons is interlinked with the, you can say, system of the imprisonment, which originated somewhere in the 19th century. So initially the prisoners were sent for the detention houses in the homes, and they were the under trial. So what was the purpose? The people who were found guilty of the certain offenses, like the, you can say, crimes against the state, or you can say any of the defaulters in the loans, in order to you can say get a confession from them, they are sent there, right? So the mostly the purpose was the deterrent, or sometimes it was the retributive as such. But in the present day, penology centers around the imprisonment, and the imprisonment is basically focused on the rehabilitation of the offenders. So that is why whenever, so I belong to the state of Punjab, right? So here you can say, whenever you'll go to the central jails or the other district jails, so what you'll see there, so in the vernacular language, it is written Sudharkar, which in English means a rehabilitation homes, right? So the people are brought there in order to bring the improvement. So the model prison system in India, essentially it is based on the, you can say, British prison system, and British prison system has further has taken, you can say, its motivation from the American prison system. So in the medieval days in America, there was, you can say, a deterrent theory which was on the place, a very barbaric and, you can say, a very odd or very brutal kind of the punishments were used against these very particular offenders, and they were tortured to the extent like anything. But there was a study during that very particular time of a period, that even for the petty offenses, you can say the punishments like the imprisonment for life, the punishments full of the torture, and even the death penalty were given. A survey was conducted back then, and it reflected that in spite of such a cruel punishments, it is not serving any deterrent effect. So, the purpose of the punishment at those very particular times was to deter the criminal. But right now, we have changed the ideology. It is to deter the crime and to rehabilitate the criminals. So the study was conducted, and it was found that these very particular, you can say, tortures or the brutal treatment, they are not creating any kind of the deterrent effect on the prospective criminals, and the, you can say, crime rate is increasing. So as an answer to this, the charter, 10th charter of the 1862, it came into the force, and some kind of, at that very particular time, some kind of, you can say, provisions, some kind of a flexible provisions were made there. So the provisions, like the, you can say, prisoners would be entitled to the bail. Earlier there was no concept of the bail. A prisoner's choice would be asked with regard to their clothing, with regard to their foodstuffs, And if anyone is, you can say, imprisoned illegally, or you can say on any of the false allegation, the compensation should be given to that very particular person. The system of punishing the offenders in the public place, now that was abolished. So these were the, you can say, in the year 1862, these were the major reformatory steps which were taken in America. Same as the was the case with the, you can say, British in England also. So the prisoners were treated brutally. Even, you can say, we can find the mention in our books of the criminology and the penology that even for pickpocketing, the, you can say, the punishments like the death penalties were given. Again, the findings were the same, that it is not creating any kind of the deterrent effect. Then the Pope 11th also advocated the human treatment to the inmates, and finally, the Certain Liberal Act were passed in the year 1778 by the British Parliament in order to make some kind of the reforms in the prison system out there. So if we'll talk of at the international level, so International Panel and Plenary Commission and the prison reforms, so it has been working since 1929 on the standard minimum rules for the treatment of the prisoners, which could be uniformly applicable throughout the world. But its attempt failed because of the variation in the geographical, physical, and the political conditions. So, our international law from the time to time, with the even with the help of the draft of the standard minimum rules for the treatment of the prisoners, which was submitted by the first Congress of the Prevention of the Crime and Treatment of the Offenders, which held in the Geneva 1995, be it the UN 10th Congress in the year 2000, right? So the objective of all these very particular international conventions or international gathering was that in order to we should be adopting one uniform approach, which should be reforming the prison system. Adopting the uniform you can say approach at a world level is again a kind of you can say a kind of a challenge in itself, due to the geographical, physical, and other political, you can say, social legal issues. So it's not that it is not a national concern; it is the international concern altogether. So when we talk of the Indian prison system, we will, as we generally divide our history into the ancient, medieval, British era. So the well-organized system of the prisons is known to have existed in India from the earliest times. So it is on record, right, that Abraspati led the great stress on the imprisonment of the convicts in the closed spaces. So Manu, the lawgiver of India, was against the same. The Kautilya in his Arthashastra also stated and mentioned a number of, you can say, instances where the forts were used in order to keep the people there as you can say as convicts if they have done something wrong. The object of the punishment under the ancient Hindu and under the Mughal period was to deter the offender so that they will not be repeating that very particular crime in the near future. So the punishments like the death sentence, whipping, flogging, all these kind of punishment, and even the punishment at the public places, they were allowed. So, if we will be talking about the prison reforms, right? So, the history will tell us that as soon as the British, you can say, rule got established in India, so from that very particular time, we started talking about the some kind of the prison reforms in India, right? Be the effect of our, you can say, independence movement at that very particular time when our people were lodged in the jails. They were demanding the proper food, clothing, and the environment, right? So that means at least the human conditions, right, where you can keep the humans even if they have done something against the rules of the state. So the second jail inquiry committee was established. The first was established in the year 1836. The second was established in the year 1862. All these committees, they expressed its concerns, right? That how the, you can say, problems in the jails, in the institutional setup could be solved so that a kind of a good environment should be given to our prisoners again. So these are the committees. They come up with a very good piece of the recommendations, right? In reality, right, what is their fate, right? The recommendations of the committees are such, you can say, as such, are not binding, right? So that is one of the thing, and most over the resources of the state also plays an hurdle into it. So that this very particular slide on our screen, it is talking about the evaluation of the ancient to the modern prisonization, at least in our country, in India. So, talking about some of the more Indian jail reforms committees in the which was formed in the year 1920s, right? It was suggested, it was chaired by Sir Alexander Cardio, and it was subjected that every jail should have a maximum intake capacity to be regulated based on the basis of its structure, its form, right? So that means it's not that that whosoever is coming should be lodged in the jails. Every jail should have the maximum capacity depending upon the facilities available there, after reviewing the situation of the prisoners, right? So what kind of you can say space is required to them. So this very particular committee of 1999 and 1920, it gave the number of recommendations on it. So, after reviewing the situation of the prisoners around the world, the Commission concluded that institutions should not only have evolving theories but also the rehabilitation strategies. So, they way back in the 1919 and 1920s, we started talking about the rehabilitation of the criminal. So the report is stressed on the need of the reformative approach to the convicts and condemned the practice of the physical torture inside the prisons. So the key part of the committee recommendations was the importance of the post-release rehabilitation programs for the free convict. What to talk of the 1990s and the 20s, even if today also, right, any person is coming out of the prison, a societal stigma is attached to that very particular person. And if you will not be providing him or her with any kind of the rehabilitation facilities so that he or she can earn right respectfully for him or her for the family, so that and the person is serving in the jail for 5 to 3 years, there is, you can say, no purpose of that very particular punishment. Prison reforms after the independence, right? After the independence of India, the work on the reformation of the jails, it speeded up in the year 1956. The punishment of transportation was substituted by the imprisonment for life. Earlier, we have studied that the prisoners of the serious crimes, they were transported to the Andaman and Nicobar Islands, right? So that was stopped. Then it got converted into an imprisonment for life. In 1949, we have a Pakwasa committee which gave the permission to take the work from the prisoners in making the roads, and for that the wages should be given, right? Earlier America, the prisoners were used, their, you can say, skills were used for the purpose of the development of the state infrastructure or the nation's infrastructure, like building of the roads, but for that no remunerations were paid to them, only, right? So only they were made to work and they were given the, you can say, the food for that. But in 1949, right, at least in India, it was suggested that let's utilize the human resources and just give them the wage for that. So after that, we have the recommendations on the prison reforms in the year 1959 by Dr. W.C. Reckless. He was a technical expert, right? Later on, the committee was appointed to prepare the All India Jail Manual in the year 1957 on the basis of the suggestions given by Dr. W.C. The government of India appointed All India Jail Committee in 1857 to prepare a model prison manual. The committee submitted its report in 1960. The committee was asked to examine the problems of the prison administration and to make the suggestions for the improvements. And the suggestions were given. Again, it was the recommendations. Further, we are having the long list of the committees. So, All India Committee on Jail Reform was established. Then, the basic objective of this very particular committee was to reform the criminal justice system, right? And with that, the new regulations we had in the year 1986, the Juvenile Justice Act law, especially dealing with the minors, those who are in conflict with law, they need not to be lodged in their regular prisons with the hardcore criminals, right, or with the adult offenders. So the separate setup was made for them in the form of the observation homes and the special homes. Another committee headed by the Justice V.K. Krishna Iyer, right, in 1987 was appointed to understand the situation of the women prisoners. And still this is a, you can say, crucial area even today in 2023, right. One of my PhD scholar, right, she's doing the empirical work on these prison reforms. And let me tell you the condition when you talk about the women prisoners, right, ground level, it is pathetic condition. As far as she has taken our data from some of the prisons, right, in the state of the Punjab. Although, right, in your prison manuals, in your books, everything is there, right, separate. Even some of the prisons, right, don't have the separate, you can say, toilet facilities, right. So this is the kind of the, you can say, situation at the ground level. Even after, you can say, the committee suggested so much of the changes in the year 1987. So this is the area where, you can say, the reforms are required. Now, how the reforms could be done as such, we all know prison being the constitutional law students. So the this very particular thing comes under the seventh schedule of the constitution, where you can say that is on the state lease. So the states are having the exclusive domain, right, to form the various prison manuals for their respective state governments. So that, so does the states play the primary role responsibility to change the, you can say, current you can say, law relating to the prisons and to reform them. Then when we talk of the prisons, right, so the first act, or the act which was made during the British era, was the Prison Act of the 1894. If I talk of this very particular act, in the nutshell, this very particular act to talk about number of the things, as the slides will be telling you, right. So what should be the structure of the prison, right, and how the prison, what would be the kind of the prison staff, the medical officer, superintendent of the jail, and what would be their powers, right. So what is the organization? So means to say that this act is talking about the organizational setup of the prisons and more, and it has a very less or a very minimal to do with the reformative techniques which should be adopted in the prisons, right. So the chapter 1 of the act is dealing with the criminal, the number of the you can say criminals, how they could be bifurcated. The chapter 2 was talking about its accommodations, how, what is the minimum criteria for the accommodation, then the people who are the playing the responsible roles in the administration, let it be the director of the prisons, right, be it the superintendent of the police, right, so be it the other official, the medical officer. So it is giving the you can say the things that these people would be, you can say, accountable for it. And one more thing which I have analyzed in this very particular act, this act itself is not giving the powers to the officers, right. This is a central act. It has to, it need to be implemented with the help of the states, when the state is the, you can say, the prison is the subject which is coming within the state list. But still some of the, you can say, guidelines regarding the powers and the functions of these very particular instrumentalities, it has to be given, but the act is completely silent on it. The entire powers has been given to the state government, and when it is given to the state government entire powers, there is nothing wrong in it. Still, if we want to take the nation as a unit, and there would be again the problem in the uniformity of the rehabilitation processes as such or anything. Otherwise this act is not directly talking about the rehabilitation. So the superintendent of the jail, right, so how the jails would be taken care of. So there is you can say the chapter 3 provides about the control and the duties of the officers of the prisoner. The subordinate staff has to act under the direction of the superintendent of the jailer. So the some kind of the do's and don'ts has been provided for the jail staff, that they will not be indulging into any type of the activities like selling anything inside the jails to facilitate the prisoners. So they all these very particular kind of things has been made as an offense, right? So they are not allowed to do this. And secondly, the dues which they need to maintain is they need to maintain the register, right? So what kind of the prisoners are there, how many of them are under trials, how many of them are convicted, what sort of punishment they are going on, what is the date of their release if the trial is going on, what is the, you can say, date of the next hearing, and if you can say the bail is given. Now see, this is again the, if any person who is ignorant, who is not having the free legal, who is not having any personal advocate, or who is dependent upon the free legal aid, sometimes the people get the bail from the courts, and then that very particular bail need to be, you can say, communicated to the jail authorities, right? And so then accordingly the administrative process will take place, but sometimes the gap remains there only. The person is getting the bail from the court, but it is not timely given there in the, you can say, in the jails, in the correctional institution where the person is residing. As a result, right, it is leading to the, again, the illegal detentions, right? So that is another area which has to be taken care of. So the act is talking about the medical facilities, that what sort of the medical facilities which should be provided to the prisoners in the jail, right? So the superintendent or the director of the prison for the information, these are the two, you can say, authorities which has been designated, which has been made responsible for providing these very particular medical facilities, obviously along with the medical officers. And if you can say death of any prison occurs within the premises, right? So every detail, right, what was the disease from which the person was suffering, how many times the doctor visited him, what kind of the medicines was prescribed, right? So what was the, you can say, what was the cause of the death post-mortem, everything has to be done. So these are the specific rules which are provided under the Prison Act. Then we are talking about the jailer. So the duties of the jailer is duty bound to reside in the prison and not to leave even in the night. That means he is the caretaker of that very particular jail at that very particular time. He is responsible for the safe custody of the records, documents, and any other article, and plus the safe custody of the inmates as well, right? So the act, instead of providing the detailed provisions for the powers and the duties of the jailer, deputy jailer, or assistant jailer, it has provided the state government to frame the rules on it, right? Again, right, the same thing. So act is not giving the, you can say, a direct directions that what could be the rules, what could be do's and don'ts, right? They are leaving it to the respective state government. So these are the critical analysis of the Prison Act, so which we are doing side by side. So first is, it is talking about the functions, how the prison should be functioning. It is talking about the infrastructure. So the act is not at all talking about the rehabilitation of the prisoners, right? So the act has, obviously it was made in a colonial era, so it has a colonial approach and defects with the contemporary ideology of reformation of the prisoners on the humanitarian grounds in order to change their heart and the mind and to become responsible towards the society. The prisoner should not be just left on its own in the prison to languish and to suffer like a dead creature, right? So responsibility of the state is that if someone has done something wrong and we are putting the person in the prison, we should take the responsibility as a state to rehabilitate the person in whatsoever manner it is possible. So, as per the words of Honorable Justice V.K. Krishna Iyer, reformation should be the dominant objective of the punishment. And during incarceration, every effort should be made to recreate the good man out of the convicted person. As we say, our criminal justice system talks that we are against the crime, not against the criminal as such. So, same the wise words by Pandit Jawaharlal Nehru. Criminals are largely the creation of the societal conditions and therefore they are required to be treated rather than being punished. So, reformation is the treatment. That is why the prisons are known as the correctional, you can say, institutions. So, very recently, we had the Model Prison Act of 2023. The Model Prison Act of 2023, it is notified on your 12th May 2023 by the Ministry of Home Affairs, Government of India. It is a comprehensive law that aims to reform and rehabilitate the prisoners while also ensuring their safety and security. Now, this is the, you can say, one of the landmark thing with which on the human, you can say, human rights approach, ensuring the safety and the security. The act replaces the British era Prison Act of 1894. All the deliberations which we were doing on the act earlier in the nutshell, right? So this law on the statute book has replaced the earlier act, which was outdated, and so this very particular act coming onto the statute books is again giving us the ray of hope for the further, you can say, future reforms in the country. So the significance of the act is that, one minute. So when I talk about the, you can say, important features of the act, this act is focusing on the rehabilitation and rehabilitation. It is emphasizing the importance of reforming and rehabilitating the prisoners. So they try to reintegrate into the society after their release. It provides a number of measures to achieve this, such as educational trainings, vocational trainings, and the counseling. So that is the must step which should be adopted, right, by every state government. It should be made a part and parcel of any, you can say, prison setup. Better living conditions within the prisoners, right? So the if we look at the records, if you look at the record of 2021, right, our prisons are overcrowded. And when they are overcrowded, we can think of that what kind of the, you can say, living conditions are there, what kind of hygiene is there. So this act is, you can say, specifically talking about that, the better living conditions, right? The minimum standard for living conditions in prison, including the adequate food, clothing, shelter, and healthcare. It also provides for the segregation of the different categories of the prisoners, such as the women, children, and transgender. And the transgender, for the first time, is, you can say, finding the place in this very particular laws. So the use of the technology, the act encourages the use of technology in prison administration, such as electronic surveillance and video conferencing. This can help to improve the security and reduce the cost. Human rights safeguards, the most talked about thing, the thing on which generally our Indian criminal system, our Indian, you can say, administration, right, it is being targeted that we don't care or we violate the human right of the prisoners in one form or the other. So the act is talking about it. The number of the human rights safeguards for the prisoners, such as right to free legal aid, right to be free from torture and cruel and unusual punishment, has to be there. Now, right to free legal aid, so that we have provided way back, right? So that was the part of the constitutional itself. But the thing is that, again, uh, when you talk of the reformation in the prison, education, vocational training, and awareness, right? These are the three key words with which we can reform our prison administration. Prisoners are there, obviously. Majority of the prisoner, those who are going into the prisons for the petty offenses, for in order, some are just doing the wrong acts in order to survive their livelihood. We know that from which strata of the society they are, right? So they are not equipped enough with the skills. It's not always they are not the incorrigible offenders. So the lack of awareness is there. We are providing the free legal aid to them, right, for them, right? They can apply for the free legal aid, but how they will apply until and unless the administration, the state, is not taking the initiatives to make awareness, right? Awareness about the human rights, awareness about the different rights available to you under the Indian Constitution, awareness about the different rights available to the convicts under the different laws, how they could be represented in the court of law. That is, you can say, one of the important thing which could be done, right, under the new prison act. So the significance, the importance of this very particular act, it serves as a guiding document for the state for the adoption in their jurisdiction. So it has been, you can say, again coming over to the fact that it is the state subject, right? From the time to time, the states might be making the rules and making it applicable in their respective states. And this very particular Prison Act of 2023, it has done with the Prison Act of 1894, along with that the Prison Act of 1900 and the transfer of the Prison Act of 1950. All the provisions, relevant provisions relating to it, so it also get assimilated in the Modern Prison Act of 2023. Now this generally, if we as the present discussion is focused on the correctional institutions, right? So the prisons, observation home, children home, right? And even we, in some of the places we are having the foster homes also, right, are very rare, right? But still they are there. Right, so the for the purpose of the categorization, we can divide the correctional institutions or jails into sub jails which are operating at the tehsil level, right? And if you will be looking at the jails which are operating at the tehsil level, you can visit any of the jail around you. If it is there in your tehsil, you yourself can look at the pathetic condition there, right? The pathetic condition of lodging, especially, right? And you can say the proper, even the, you can say, equipment needs, or I can say the things needed for our daily lives, they are not there. Then coming over at the district level, where the under trial prisoners and the convicts, right, they are there. So at the district level, some facilities are better as compared to the sub jails. Then and at the highest level, we are having the central jail. So this is how we will be, you can say, dividing it into the sub jails, district jails, and the central jails. Then we have the women jails. We have the concept of the open prisons, right? Although, right, we do of the we do talk about the open prisons, right? The concept taken from the Western world, but still in our country, right, as per the latest data, only the 42, you can say, around 42 open prisons are working, and majority of them are working in the state of Rajasthan, right? So only, so there is a need, right, to increase that. And especially when we talk about the non-institutional setup or non-institutional, you can say, correctional measures, especially when we talk of a parole. So number of your jurists, criminologists, and they have suggested from time to time that once the person has served, that even the person was into the jail for any, you can say, hardcore crime, right? So once the, you can say, one third of the punishment has been served by him, he should be shifted to the open prison. So he should be, you can say, trained that he is the responsible person in the society. After going out from the jail, he is going to take a very important role. He is going to contribute towards the growth of the country, to the growth of the society. So that very particular feeling, until and unless that feeling is not inculcated in the prisoners, in the convicts, right, we cannot, you can say, decrease the crime rate in our country. Looking at the, you can say, on your slides, as per of 2023, some of the latest data about the correctional institutions has been collected. So we are having the 1306 correctional institutions in India, including 145 central jails, for 13 district jails, 565 sub jails, 88 right open jails from the 42 to up to 44 special jails, and 29 women jails in India. The Indian prison system is administered by the respective state government, but apart from it, right? So if some cases being handled by the special Central Bureau of Investigation or the National Investigation Agency, so they are operating their own prison system, right? Anything, right? So any criminal doing something very serious for which the CBI has to be involved, or where you can say any matter which is affecting the security of the country, national investigation agencies involved. For that matters, we are having the different setup of the prisons. So the primary objective of the Indian prison system is to deter the criminal, to rehabilitate the offenders and to protect the society. However, the system faces a number of challenges, including the overcrowding, poor infrastructure, and the inadequate staffing. And whereas you can say inadequate staff, that is the one of the major problem in the prison system in our country. Recruitment, you can say right now at least you can say I can relate to the state from where I am. Right, recruitment in the, you can say at the constable level, right, is quite much, right. Every day there is a test for the recruitment, or there is a test for the you can say for the promotions into the head constable and all that. So that is in the police domain, right. And if you talk about the, you can say, recruitments specifically for the purposes of the jail staff, for the prison staff, that is not there, right. For the investigation and other purposes, the states are doing much, right. So they are employing the people, right, so that the administration of justice could be made much better. But inside, when where the prisoners are being kept, so the recruitment is not so much, right. So some of the correctional reforms in the Indian prisons, like especially the prisons like the Tihar jail, number of, you can say, correctional measures are taken there. So several programs like the educational programs are there, and the educational programs are also conducted in the prisons. Formal and adult education, right, arrangements has been made where you can say your the universities like the Indira Gandhi National Open University, IGNO, and National Institution of Open Schooling, it is playing the major role. Number of the prisoners, so this very particular data which has been taken, it has been taken from the one of the survey from the Tihar jail, right. So in the Tihar jail, 2640 and 1900 inmates are respectively enrolled in the different courses in the IGNO or the National Institution of the Open Schooling. That means the some kind of the opportunities are being provided to them. Many of the inmates who joined the reformation by the education courses have been rehabilitated successfully. The government is responsible for spending on the tuition fees for them. Then we have the Ministry of the Human Resources Development Department. It is working for the adult education, providing the qualified prisoners with the training to allow them to teach the less educated one, right. So that means, so there the people are training each other. Rehabilitation of the prisoners was started with the primary objective of the difficulties that are faced by the prisoners after the reform, after the post release. Today any person of 19-20 years has committed any crime because he is a jobless, right. He is not equited, the life was not fortunate enough on him, that he was not having, or his parents were not having the means to send him to the school so that he could be made skilled or in any other job. So these kind of the vocational trainings, the educational setup that are being conducted in the various jails. But this very particular data, if I am talking about, it is exclusively from the Tihar jail, right. So that they are working good on to it. So if I'll talk about the non-institutional methods, right, probation, parole, we all know. So the, you can say again, the starting point of these very particular correctional institutions stands with the Western world. But here in our India, in our country, we are having the Probation of the Offenders Act. So this very particular Probation of the Offenders Act, it talks about the release of the criminal, or release of the person, right, if taking into the facts and the circumstances and the seriousness of the crime, only after admonition he should be released, or he should be released after taking the security, and no punishment or sentence should be granted to any person who is below the 21 years of the age. So the probation is a kind of the reformation technique, it is a treatment, right. So the act is talking about, the act is giving, right, although it is the, you can say, a judicial process where the the judge is given, you can say a magistrate is given a liberty that even he can pronounce the probation after pronouncing the sentence, or even before pronouncing the sentence on the offender. It is one of the, you can say, important measure. When you talk of a parole is again, you can say, the another thing, how the parole is different from the probation. Parole is, you can say, purely it is administrative in the nature, purely, right? So generally, this very particular, the in the parole, the prisoner need to, you can say, get into some kind of the punishment. He has already undergone a punishment, then that very particular person would be allowed to, you can say, go on a parole. So when we talk of the parole as an, you can say, measure for the criminal reforms, it was the first United Nations Congress on the treatment of the offenders, which was held, which we have earlier also talked about, which was held in the Geneva in the 1955. It suggested that the premature release should be there. Again, the same suggestion was made in the year 1960 by the United Nations Congress, which was held in the London. Right? Historically, the concept of parole has its origin in the military law, where the prisoners were allowed, right, where the war, the prisoners who were convicted of the war crimes, they were allowed to, you can say, to stay with their family for certain very particular purpose and come back. It is a release from the prison after the part of the sentence has been served, but the prisoners still remain in the custody, right? He still remains in the custody. He is under the supervision. So parole is it is generally said that a parole is the last stage of the correctional scheme, of which the probation may be perhaps the first one. So whenever you look at any particular offender as a magistrate, he is a young offender, he has a chance of a rehabilitation. Instead of sending that very particular person to the jail, you as a magistrate, you are having the power under the Probation of the Offenders Act. You may release him on the probation with or without supervision, depending upon the facts of the case, right? So if he violates any of the conditions of the probation and all that, he need to serve the entire punishment. Once he has, you can say, some time of the punishment has been undertaken already, then he can apply for the parole. Parole is, you can say, entirely the administrative decision. It is entirely depending upon the conduct of the person. So it is significant to note that parole involves both the punishment and the rehabilitation at the same time. So when you are out on the parole, right, journally, you can see, when you will be analyzing the majority of the judgments, like the Sunil Fulchand Shah versus Union of India, or Arvind Yadav versus Ramesh Kumar and others, it is said that you are under the sentence only, right? So the parole is the one form where you can say punishment and rehabilitation is given at the same particular time. So it is a quite an effective measure for the rehabilitation of the offenders. Then coming over to the furlough, right? So that is the another reformatory tool that is used, and it is often confused with the parole. Undoubtedly, parole and furlough are the reformatory tools for the penal system, but both are different. Furlough must be granted to the prisoner periodically, irrespective of any particular reason. In the parole, you need to establish the particular reasons, right? You need to establish, the prisoner can say that there is a marriage of my daughter, my mother is not well, right, coupled with his good conduct, right? So it is not a right of a prisoner, right? He need to establish his case before the, you can say, this prison's board, and after that only he would be, you can say, sent out on the parole. On the other hand, that furlough, it is quite a temporary in nature. It is without any particular reason, right? It is a short term release, and parole is the conditional release. So it is done furlough and parole, they are done as per the jail manuals, right? So then, when you were talking about the reformation of the prisoners' rights, so constitution is providing and the two rights or the, you can say, under Article 72 and 161 to the president and the governor, right? They have the, you can say, right to pardon. It could also be talked about as one of the thing which we are talking about, the reforms. Then we had an open prisons. Then coming over to the another concept, which is the restorative justice, right? So restorative justice, if you will be looking at these days, we are, you can say, putting the more emphasis on the mediations, we are alternative resolution of a dispute, and even your new motor, you can say, amendment in the Motor Vehicle Act of 2019. Now, so the emphasis is made that out of the court settlement, out of the, you can say, this very particular institutional settlements, right? So you will be settling there. Obviously, declarations would be done from the court of law itself. So the restorative justice is putting an emphasis on the fact that the criminal and the victim should be brought at some common point where the victim satisfaction is the highest one, right? Earlier till now, right, we were talking until and unless year 2013 amendments, we were talking about the accused only in your CRPC, fair trial to accused, everything. Nothing was about the victims. Even the original CRPC was not having the definition of the victim as such, right? From that angle, we were talking about. So the modern, you can say, concept of the penology is that along with the reformation of the prisoners, right, in order to release the burden on the prison administration, so the restorative justice could be there. So right, so it could be by whatever means, so that the victim should be feel satisfied, right? So according to the National Crime Record Bureau, in the 2019, it found that a recidivist rates for the offender who participated in the restorative justice program was 20% lower than the recidivist rate for the offenders who did not participate in the program, right? So when you are talking to the victim of your own crime, when you are bringing them together at at the one platform, it is the another, you can say, measures which can develop the humanitarian, you can say, approach in our offender. Same is the case with our community services. So this type of the punishment requires the offenders to perform the unpaid work for the benefit of the community. Generally, it is the feeling which we need to inculcate in the offenders that we belong to the society. Along with the rights, we have certain responsibilities. Nowadays, not even of the offenders, if you talk about community services, as we all are the teachers, right? So we should make it a point that it should be made a part of our curriculum itself, in our internships itself, a community services. So from the very beginning, when any, you can, obviously, the children, the young blood of today, those who will be adult tomorrow, they might be doing something wrong, right? So if the compassionate feelings, right, the feeling of belongingness to the community, right, it is inculcated from the very inception, right, then from very beginning we can curb the rate of the crime, and obviously it would be curbing the rate, you can say, the criminals in our country, right? So in 2018, the study of Tata Institute of Social Sciences found that community services programs were effective in reducing the rate of the recidivism, right, and improving the rehabilitation of the offenders. It is a quite an effective tool which could be used in the prisons altogether, specifically, you can say, prisons, and generally, you can say, in our all the social institutions, right, in which, you can say, obviously, the subject matter is the human being, right? It should be used so that we should not be, right, the people should not be going to that very particular stage where they are forced to commit crime by the way of the circumstances. So these things will, you can say, provide a kind of the genuine and a compassionate approach in the heart of the people. So then the diversion programs, these programs provide the offenders with an opportunity to avoid the criminal prosecution by completing the treatment programs or other requirement. Diversion programs can be particularly effective for the first time offenders who are struggling with the addiction or the mental health issues. So for in 2017, the study of, again I have taken the National Institution of Drug Abuse, found that diversion programs were effective in reducing the recidivism rate and improving the substance abuse treatment outcome for the offenders. And if you will be looking at the chain of the crimes and offenders along with the drug abuse, right, it is a quite a, you can say, a very close nexus, right? So all these very particular things are attached. While there is a limited data on the success of the alternative methods to the punishment in India, but still we can try it on the experimental basis, and obviously there would be the success. Apart from these very particular things, we are having the another mediation, counseling, education and training, and very recently we are the mediation act. Now the mediation is supported by the statute, mediation act of 2013. All these very particular things could be used in order to improve the criminal system in our country. It is important to note that there is no one size fit all approaches to the punishment. The best approach for a particular offender will depend upon the variety of the factors. Means here we are talking about the individualization of the punishment, right? So one factor might act good for the one prisoner. In the same way, one rehabilitative technique may work good for the one person, but it may not work good for the other. While giving the punishment, we talk about the individualization of the punishment. In the same way, while reforming the prisoners, while giving the reformative, you can say, treatment to them, I would say the individualization reformative treatment is the need of the time, and for that we need the more support from the state, the more staff from the state, and apart from it, the, you can say, the compassion in the heart of the staff which is dealing with these very particular offenders, I would say, or with these very particular people who need the rehabilitation treatments. Thank you. So this is all from my side.
Thank you so much, ma'am. It was a wonderful session. And I think the slides were quite informative on the
I hope
basis
I
of,
was audible in the entire
yes,
session again, as
yes, ma'am, from the,
but I am unable to hear you. Right, same problem persists.
so ma'am, can you hear me?
Do we have some chat box available? So if somebody is having some questions.
Yes, ma'am. Ma'am, we have few questions that pops up in our mind every time when we think about correctional institutions. So, ma'am, the first question that, with your permission, I would like to take up is, uh, ma'am, what is the significance of parole, and how far its role is successful in Indian correctional system?
If you can write in the chat box, I know someone is asking some question. I can figure out this thing, but you can say I can't understand.
Okay, ma'am, I'll just write it down in the chat box. Ma'am, there is a question in the chat box, if you can see that. Ma'am, the first question is, what is the significance of parole and how far the role of parole is successful in Indian correctional system?
What is the significance of? I can
Parole.
understand till significance only. So I think we have one chat box in the private chat. I have also messaged there. Can you hear me? There is one chat box available on my screen. What is the parole and how far the role of successful in India? Okay, okay, got it. What is the significance of the parole and how far the role of the parole is successful in the Indian correctional system? Okay, so parole is you can say when we will be generally as a criminal law student when we generally review the literature regarding the parole, parole plays a very much effective role, right? But if again it is the again if it is rightly given to the right candidates, right? So generally the role or the significance of the parole is that the what was the motive that a person, the prisoner who is there inside the jail, he will not get altogether cut from the family ties, right? He should have the sense of the responsibility. It is playing a quite significant role in the, you can say, in our prison administration system. And one I can give you an example. The person who is working as a gardener with me, that way he committed some of the crimes in the, he was voluntarily intoxicated about 4 years ago, and he committed one crime, right? And he was into the jail, and otherwise he was not, you can say, such kind of a person, but the jail was pronounced, he was there. So now he was out on the parole, and he was living with his family, and he was adamant that he will not touch the liquor. That very particular thing has wasted his 7 years of his life, and now coming back on the parole, you can say reintegrating the ties with the family and with the society, it gives the person the feeling that what he has lost while doing that very particular wrongful act. And whereas its successful role in the Indian correctional system, it is quite a successful, right? If we will not be taking some, you can say, obviously both sides of the things are there. Sometimes it is being misused also, right? So that is also, there is no denying the fact in some high profile cases, right? Parole as an instrument of the correctional justice, it is being misused, right? Every second day the parole is given to someone. But if we will look into root level, if it is given, right, so it is a very good process. But one thing which the practical, you can say, a problem in the parole is there, you need to give the surety and security for that also, right? So when the prisoner is from a family which that very particular family is not very well to do, and that very particular family is not having the good means of the livelihood, it becomes very difficult to give that very particular surety. So that thing should be taken care of, and it should also be following, right, within the pursuit of our free legal aid or under any other scheme it should be coming. Otherwise, in my opinion, it is, you can say, playing a very significant role as a correctional, you can say, method in our today's system.
Thank you, ma'am. We have another question from one of the participants.
uh, okay, I had a question, ma'am. What are the challenges faced and reform regarding that? Yes. So again, in the terms of the implementation, right? So as we all know, right, it depends on the resources, right? Both intent and the resources of the state. We right now the implementation as far as the of the prison reforms, that is there. We can't deny the fact that it is not there. It is there. It has started. People are working right on those very particular lines, and the jail authorities and the you can say these jail personals, right? They are taking the effective steps. And let me tell you the instances, right? The people from the law field, right? They are being called for giving the awareness sessions there. It is there. Yes, you can say in such a big country with so many problems, right? That we may feel the change after some time, right? That is quite acknowledging the fact, but it is not that it is not there. It is being implemented. Pace might be slow, I can say, right? Pace might be slow, but it is there, and the respective state governments, they are taking care of this very particular fact, and hope so, right? The young generations, those who are going to be in the system tomorrow, and they will be paying the more attention towards it. It is there.
Thank you once again, ma'am, for answering these typical questions. And I think the participants are much satisfied with the queries, as well as the whole session was so informative. We got to know various
Okay, thank you
facets of
so much,
correctional
ma'am.
systems.
Thank you so much for extending this invitation to me, and thank you for making the part of your family by the way of this very particular program. I want to thank all the conveners, the head, all the authorities, patents of the university for organizing the program. And I would also request that if you have clicked some of the pictures of the session, I will request that if you can send me by the way of mail. Thank you so much.
Sure, ma'am. Thank you so much for taking out your time. And we are really, really honored to have you on this session. Thank you so much, ma'am.
Thank you so much, ma'am. Pleasure is all mine. Thank you.